Okay, Brzoska v. Olson. This is a case about the specific intentional tort battery, which is, like fist fights and, battering people. So we've already established that an element of the plaintiff's case in all intentional torts is first need to prove intent. But battery has its own additional elements, and Brzoska kind of gets into that. All right, so Olson was a dentist with AIDS, unfortunately, and this was the 90s when people were pretty ignorant about AIDS. And not to say we're not ignorant now about a lot, but we were really ignorant about AIDS in the 90s. And Plaintiff is one of 38 of his patients that all sued him for basically putting his fingers in their mouth when he had AIDS. Um, Technically, Olson had already died, and so they're suing his estate, but that's beside the point. So the lower court ruled for the defendant, and then the Supreme Court in this case affirmed or agreed with the lower court that the plaintiff patients did not prove their battery case. So to prove battery, you have to first prove that the defendant acts intending to cause harmful or offensive contact, and you need to prove that a harmful or offensive contact directly or indirectly resulted. So the big question is, what does offensive contact mean? Because the defendant wasn't putting the patients in the dentist chair and then just socking them straight in the mouth. He was just performing dentistry. So, was a man with AIDS putting his fingers, which were covered in gloves, in the patient's mouth, an offensive contact akin to being punched? So the Supreme Court gives us, in this case, the definition of offensive contact required to succeed on a battery claim. So offensive contact means it's both offensive to one's dignity to a degree which would offend an ordinary person, and the contact must be unwarranted by the social usages prevalent at the time and place it occurred. So basically what that means is that a normal person would be offended by it, and it has to have been offensive given the time and the place where it happened. And basically, the Supreme Court held that, it's such a low risk based on the science and the evidence given about AIDS to assume that, a dentist using proper, dental gloves and whatnot would transmit the disease. So they basically held that, the fear wasn't reasonable. Additionally, they adopted something called the actual exposure test, which means actual exposure to a disease-causing agent is a prerequisite before you can prevail on a claim of basically a battery based on you contracting a disease. But again, the most important thing to take from this case is the definition of offensive contact for battery, which is that the contact is offensive to one's dignity to a degree which would offend an ordinary person, and the contact would be unwarranted by the social usages prevalent at the time and place it occurred. Again, word salad. So let's give an example of both of those elements of an offensive contact. Element one: no one likes getting spat in their mouth. So, if you spit in anyone's mouth, they're going to be offended. That would offend an ordinary person. That's a battery. Spitting in people's mouths, you might as well just punch them in the mouth. It's still a battery. But on the other hand, let's say I'm a weirdo who is really grossed out by people accidentally touching my foot with their foot underneath tables. Let's say you accidentally touch my foot under the table. I can't sue you for battery because that contact wouldn't be offensive to an ordinary person. No jury would agree with me that that was offensive. Element two of the definition of offensive contact: the contact has to be unwarranted by the social usages of the time and place in which it was inflicted. So imagine a Little League football game, and my kid's playing, and your kid runs up and tackles him in the game. Me and my kid can't sue you for a battery because that contact isn't offensive given the time and place where it occurred. Now let's change it a bit. Let's say it's a Little League football game. Our kids are playing, and I run out and tackle your kid. That sort of contact is probably offensive given the time or place. It's not expected that the parents are going to run out and tackle the kids, in the middle of an inning. So what's the takeaway? Maybe practice a little empathy for someone suffering from a fatal disease rather than suing them for some money.